Good morning, everyone. On behalf of All India Institute of Medical Sciences, Jodhpur, we invite and welcome you for this uh, impact lecture, which is going to be delivered by two experts. And the first of this lecture will be by Dr. Sumit Kalra. And the purpose of this impact lecture is as a part of the Institute Innovation Council, which has been created at AIIMS Jodhpur. And Ministry of Education has, with the Institute Innovation Council, have developed the fourth phase. And this is a 2022-23 series of impact lecture. And the purpose of this lecture is to disseminate about some entrepreneurships and innovations in our technology. So multiple talks and multiple aspects can be covered through this impact lecture. Each institute has been assigned. We have been selected. AIIMS Jodhpur has been selected and assigned to conduct two such sessions. So first such session is being conducted today. That is on the 5th of July. And this is a morning sessions which will be taken by Professor Sumit Kalra. And the second half will be taken by another experts who has graduated from AIIMS Jodhpur, post-graduated from AIIMS Jodhpur, and is working as an expert in Bangalore. So these impact lectures are designed to have the impact on the Institute Innovation Council members so that they can improve their working as well as culture, and also give some idea about how to preserve the innovations and how to have the intellectual property rights for this lecture. So again, I welcome you all on behalf of All India Institute of Medical Sciences, Jodhpur, for this first talk in this series. And I request Dr. Sheval Srivastav to please introduce Dr. Sumit Kalra.
Good morning, sir. I welcome everybody on the behalf of All India Institute of Medical Sciences, AIIMS Jodhpur, and it is a proud privilege to introduce Dr. Sumit Kalra, sir. Dr. Sumit sir has earned his PhD from IIT Kanpur in 2018, and he has joined IIT Jodhpur after that as an assistant professor in the Department of Computer Science and Engineering. The primary area of work by Dr. Kalra is the exploring the software and architectural issues related to quality of complex software systems, and areas such as edge fog computing, artificial intelligence, Internet of Things based systems. And Dr. Kalra sir has a couple of patents and more than 25 high quality publications in his name. So I request Dr. Sumit sir to kindly share his screen and please deliver his talk. Sir, please.
Thank you, Dr. Shival, for inviting me and an introduction. I'm just sharing my screen. I hope it's visible. So, good morning, everyone. Yeah, thank you for the confirmation. Good morning, everyone. And today we are going to talk about IPR, intellectual property rights, as a bird's eye view, bird's view. So it's an overview. There are a lot more detail which we can discuss, and but it will take more time. So I will keep it as a slightly abstract. abstract manner. And if you have any question, any concern, you can stop in between and we can have further detailed discussion. So briefly about our lab. So I'm part of Software Innovation Lab. We have a couple of PhDs working on it, and we have some projects which are related to healthcare also and IoT also. So mainly my work application is in interdisciplinary domain. Okay. So let's jump to the key discussion. Uh, we all know about the properties. We have movable properties and immovable properties. So like our vehicles are part of movable properties, jewelry, gold, silver, they are also part of movable properties. And then estate sector is like immovable properties. But we have another category other than movable and immovable also, which is intellectual property, and it's creation of mind. So whatever property is getting created through our intellect is known as intellectual property. Now, human mind can create lots of things. It can create ideas. It can create solution of for those ideas, or it can change the solutions to fit in another scenario. So all those are intellectual properties. If you are writing a book or an article, that is also your creation of mind. So that is also intellectual property. If you are if you are a lyricist, you are writing songs, poems. So those are also part of your intellectual property. A scientific research, coming up with a new method is also intellectual property. But not all properties are given protection. So that we will discuss today. What kind of properties are given protection by the law and what are not, and we'll also pick few properties which are more relevant to our profession. So before going into the types of intellectual property, so this intellectual property is actually omnipresent. If you uh, say IP is like competing to God, God is also omnipresent, so IP is also omnipresent. So a few examples are like pen. Whatever pen is there on your desk have multiple IPs behind coming up with that design of the pen. The procedure of refill and how ink is progressing. It's not stucking in between. How comfortable you are holding your pen. How the locking system, the cap of the pen is working. Everything is protected through IPs. The design of pen, the color combination of pen, everything is protected. The way we protect all these different things, different aspects of any product will have different category of intellectual properties. Then our smartphones, it's full of IPs, from the button where the button should be placed on the screen to where the camera should visible, how it should visible. Everything is protected from design to technology to its origin. Everything is trademarked or patented or registered as a design patent. Everything is registered. Everything is protected through intellectual property registrations. Then, in fact, furniture is also protected by IPs. So, the design of furniture, the color combination, everything, the material can be protected through IPs. Aeroplane or any other vehicle. So, there are so many patents working in aeroplane. Now you think of a scenario where an aeroplane is landing in India, but aeroplane is using some technology which is patented in India but not in the originating country. The aeroplane is coming from, say, England, and England, the patent is not valid, so it's not patented. So it's an open technology, anyone can work out. But that aeroplane is landing to India, where India is granted that patent to someone. Now the question we should ask is whether that aeroplane which is landing in India is infringing the patent rights in Indian territory or not. So here comes the link is all the IPs are territorial rights. So if you file an application for patent in India, you will get protection in Indian territory only. And if you want to have a protection outside India, you need to file the patent in each and every country where you sought the protection for your IP. So although IP is omnipresent, but IPR are territorial in nature. So it's specific to country where you are protecting your IP. Then even in your paper clips, you might be using paper clips on daily basis. So those paper clips design is also protected by IP. So let's look at the example. So you can see the two figures, figure 1 and figure 2. And so figure 1 is patent 1 and figure 2 is another patent. If you carefully look at the design differences or the working of these pins, paper clips, they're quite different. Can anyone quickly find out the difference between these two paper clips? Anyone can unmute and share your thoughts about how these two figures are different.
The space.
The space, yes. So the space between these two sides is different. Length of the pins, yes. So this the end point are much lengthier in this figure, this length. So what is the advantage of P2? So when you use P2, you clip your papers with this paper clip. There are lesser chances of getting wear and tear because these two ends are above your paper border. Whereas in this case, there are higher chances that when you remove the pin, it will tear down your papers. So even these small incremental differences are also can become, a part of your intellectual property. So in essence, innovation and inventions are everywhere. We need to identify them and present it in a particular way to sort the IP rights, intellectual property rights. Let's look at the second example. So bottle cap. In general, uh, devices are patentable. So the bottle cap, given the name is bottle sealing device. So the cap is a device which can be used to seal the bottle. Now you have different designs of the sealing devices. These are also different designs. So here in this figure, we can see 5 different types of sealing devices which can be used to seal the bottle. And each of this design is patentable. In fact, has been patented in the past. So like this is dated on 1892. And as per the time lifeline of patent, it's valid for 20 years or so. So now patent is not valid anymore, but during the 20 years, people have taken the advantage. After 20 years, it becomes open to public. So now anyone can use it without asking permission from the inventors or applicants. So as with the other property, you can buy and sell your intellectual properties also. You can also license out or renting out. But key thing we need to take care is do not infringe. That can have much bigger complications. So let's look at the different types of intellectual properties, patents, and utility models. In some countries, uh, there's a difference between utility model and patent. So utility model may not have uh, novelty aspect, but they have not been worked out so far, so they are given protection under the utility model. Patents, many of you will be aware of already, and we will be having more in-depth discussion on patents, how to search, maybe how to draft also a patent that we'll discuss in today's lecture in more detail. Then we have trademarks. So trademarks are quite important to make your market image. Like wherever you look at the symbol of bitten apple, immediately you associate the bitten apple with the quality of apple inclusive. So now bitten apple image is equivalent to the quality which Apple is giving you. And this is true for all the trademarks, all the logos, right? So trademarks are also protected and as part of your intellectual property. So now tomorrow, if I want to say sell lemon water in bottled sealed bottle, I cannot use Apple logo and give some name, say Apple's lemon. So I cannot use Apple recognition, the trademark, the logo to sell anything. So that's how Apple is protected using the trademark. And similarly, there are large number of companies which are using their logos to protect their market image or prestige. Then we have geographical indications. Now, this is the kind of property right which is in nature it's a given to public or group. Whereas if you look at these two, these are individual right. So individual entity can be single person or group of person or an organization or entity or say group of organization also in some cases. But geographical indication does not belong to any individual entity or organization. It belongs to the public who lives in that territory. So, for example, uh, tea from Assam. So, Assam's tea or Darjeeling tea or Bengali Rasgulla or Bikaneri Bhujia. So, all these entities, uh, if you pay attention, the tea, rasgulla, and bhujia, they have been identified using their origin, geographical origin. So now, if you say uh, Bikaneri bhujia, now I cannot have a factory in Jodhpur to produce the bhujia and label it as Bikaneri bhujia. Why? Because the geographical indication says that the product is coming from that territory, and the people or factories who are in that territory can use this label as Bikaneri Bhujia. And then there are certain expectations from the product. Say in case of eatable things, there's a certain expectation of audience that there will be some particular taste with Bikaneri Bhujia or Bengali Rasgulla or and Darjeeling tea. So you cannot grow Darjeeling tea in Rajasthan. It has to be grown in Darjeeling only. And people who are having farms in Darjeeling can only use the geographical indication of Darjeeling tea. And how does it benefit? It benefit the that locality, that maybe tribal population of that area. So it's kind of a protection given to that local community to protect their identity and geographical uh, unique selling points. Then there are industrial designs. So heavy machines or any production process can be registered as industrial design also. And so like JCB, JCB is protected using industrial design. If some other company wants to produce JCB, they have to come up with something which is different, or they need to get license from the JCB for producing the machines similar to JCB. Then trade secret. Like geographical indications are different from other IPRs. So geographical indications belongs to community, not to individual or organization. The trade secret are also having a special place in group of IPR. So they are also special in the sense trade secrets are not registered. So trade secrets are kept with only with you. As an organization, you keep that trade secret within that organization. You do not file any patent or industrial design or trademark. So it's a you don't need to follow any procedure. You just keep that trade secret with you. We'll look at few examples also for the trade secret. And then the last category of IPR is copyright and related rights. So copyright is given to any literary creation or artistic creation of mind, and we want to protect the writers or authors right, so that nobody can copy blindly and sell them. So in copyright there are two types of right, again economic plus moral right, and then there are associated rights also related to copyright. So copyright also and related right we will see, trade secret also we'll see in more detail, and patents also we'll see in more details. So these three are mainly relevant to our profession. So I have picked these three. So let's start with a story. So Larry Page wants to buy a mobile phone. Larry Page is one of the founder of Google Inclusive. So Larry Page, so it's a story, okay? So don't take it seriously, but it gives us a lots of learning. So Larry Page wants to buy a mobile. So he calls his secretary and he said that he wants Motorola. Next day in the newspaper, we we actually all read that Google has taken over the Motorola. Now Google is entirely in different business as compared to Motorola. So this is true story. This is true fact. This is not only a story, but the plot I'm creating to make it more interesting. So people also joked that Larry Page just called secretary to ask for a Motorola, and secretary processed the paper and bought the company Motorola instead of buying the single phone device. So it was so sudden that Google bought Motorola in 2012 in $12.5 billion. And in less than 1.5 years, Google sold Motorola in less than 3 billion. So approximately loss of 9.5 billion. And so people argue that Motorola is in the smart devices or hardware domain. It was not Google's domain, so Google by mistake bought the Motorola, and then business went into loss and then sold the Motorola, and it went to Lenovo. Now, can anyone see why Google should have done this? Anyone knowing about this matter? So it's a true story. So what could be the reason? Hint is our lecture.
Patent holded by Motorola.
Yes. So IPRs of for so Motorola was one of the leader who holds the IPs in the domain of smartphone at that time. Now Google bought Motorola and Google sold only the mobile division of Motorola to Lenovo. And whatever license, the patents were there of Motorola, that Google just licensed out to Motorola. It did not sell the patents right to Lenovo. And now you can imagine the overall mobile division of Motorola costing around 3 billion, and rest of the $10 billion was cost of those patents. So even the Motorola's intellectual property was costing at that point of time 5 times more than the actual properties of Motorola. So that is the power of IPR. So IPR can, if used wisely, it can increase your properties multiple times. So now let's look at the patents. So before patents, patents are based on inventions. So what is when we call something as an invention? So either they are breakthrough ideas, or they can be incremental but non-obvious technical improvements. Uh, Suppose there's a water bottle I'm having right now, and it's slightly harder to hold tightly, so it slips from my hand. The incremental improvement, what we I can do is I can just decrease its diameter, maybe by small values, so that it becomes bit more easy to hold. Now it's a incremental improvement, but it's not non-obvious. It's quite obvious, right? If something is bigger to hold, you are going to reduce the size. But for example, if I want to, suppose earlier the bottle was like this, now I change the bottle like this, and then I put some things on the surface so that it doesn't become that smooth, and even its water goes on the side, so it becomes wet. Still, it's good to hold. So in that case, all these things can become non-obvious. Now, I can go and file a patent for this design, but reducing the width, I cannot file a patent because this is a bit of obvious thing and this is not that obvious. So incremental technical improvements can be patentable and breakthroughs, of course, they are patentable. Now, invention is something in India, we see lots of people doing all sorts of inventions, but the thing where our country lies behind is getting patents for those inventions. So I relate my use case, like the kind of assignments which I did during my BTech or PhD. I can see that people in foreign countries are filing patents on those use cases. So my takeaway from the patent and related field is in India, we are not aware that we are doing so many inventions, but we are not filing patents. We are not protecting those inventions. And many a times we are also not publishing papers for those inventions. So neither we are having copyright nor we are having patent rights. So I would say everyone that you should look for invention more actively, and every time you should ask question to yourself whether it's a patentable or not. It's patentable or not. We are going to look at some of the criteria which can help you in answering these questions. So what is a patent? Patent is a certificate. Earlier it used to be piece of paper, a certificate on a piece of paper. Now it's a digital certificates given by the government of India. So we are talking about the Indian patents or any other patent also given by government only for any invention, and that certificate certify that you have some exclusive rights with respect to that patent. So what kind of exclusive rights are there? We'll discuss in more detail. So invention is something for which you apply for patent. So as a researcher, as an intellectual person, we go for invention. Once we document our invention and file the proper application and it's granted as exclusive rights, we say we have got the patent. Uh, I would like to clarify here that it's not only that researchers or people with higher degree education can only file patent, but we have seen that many of the inventions has also come from the rural background, rural people to solve some local problems. So it's all intellectual property, creation of mind. Anybody can come up with an invention and file a patent. Now, say we are good person of society, which we are. Now, as a responsible researcher, we would like to open up our research so that everyone can use it. And we would like to reduce the cost of living, cost of highly standard living. So we would like to open up our research to public domain so that society can get benefit. But if you look at the patents, they actually stop others from using our invention. So we'll discuss that patents are negative rights. So if I hold a patent for anything, say XYG, I can stop all of others for using that XYG technology, at least for 20 years. Now, isn't it look contradictory? At one place we are saying we want to help society uh, increase their standard of living, and at the other side we are filing patents and protecting our invention so that others can't use without our permission or without asking for license or something. So things look contradictory here, but if we understand the patent system in with more detail, it will be clear that patents are there to encourage more innovation and invention in the society instead of blocking the path of innovation. So why we should go for patent? Let's motivate ourselves. So it gives you competitive advantage. Uh, it gives you market power, or also makes you rich many of the time. It also opens up new revenue stream generation, like you can license it out, or you can build your portfolio. Based on that portfolio, you can raise more funds from banks or investors. Or as a researcher, if you have good profile in patents, there are chances that we are going to get more funding for research projects. Then it gives us freedom to operate in that technology domain for which we have filed the patent. And you can also, uh, for a business, they can also sell the relevant articles or co-articles for that patented technology. For example, if you buy iPhone, the relevant technologies like charger or wireless charging devices for iPhone. So those also will help in increasing your sale and profit. Then you can also use it uh, for better advertisement, marketing, or branding strategies. I would like to just touch upon the advertisement by Sensodyne. So we have seen uh, recently that the Sensodyne advertisement has changed in last 2 months. Before that, they were showing some person as a doctor who is not from India, maybe Indian origin doctor, but not practicing in India. And there were some recommendation coming out of that uh, person for using the Sensodyne or recommending to their patients. And other toothpaste companies filed case against Sensodyne because in India, uh, medical professionals are actually not allowed to advertise for any particular brand. So, but Sensodyne came up with workaround not to use medical professionals from India, but from outside. But then other companies filed case, and the case went into favor of other companies. Although there was no penalty on Sensodyne, but then court ordered the stay on those advertisements, citing that you cannot bluff the public by using medical professionals or similar figures to advertise your product. Okay. So, so advertisement, marketing, branding strategy also getting impacted by intellectual property rights and related laws. So let's come back to the question now: how patents help the society collaboratively in getting more innovative and inventive instead of blocking the inventions. So patent is a negative right, as I also mentioned earlier. I'm repeating again. So it stops others from using your invention instead of giving rights. So it's not a positive right in the sense it's giving you right to do something, but after applying patent, you get a right to stop others. So it's like exclusive right to prevent or stop all others from using your protected invention. And at the same time, it does not give the right to use the protected invention. So it's not saying that the patented technology can be only used by the owner. Anybody can use it, but in certain conditions. Let me talk about those conditions. Uh, for example, I have done some invention and got the patent grant. Say it's invention A. I am holding a patent for invention A. Now, first of all, it's negative right. If you use A without my permission for commercial purpose, then I can stop you. But if you build it yourself, say re-engineer it yourself, and use it for your own purpose, but not for commercial purpose, then you can use it. Now, why it is allowed? Why this case is allowed? Non-commercial plus own uses. If that is the case, you can replicate the patented technology. You are still under legal boundaries. Why it is allowed? Because say I have got patent A. Now my competitor in some other lab will reproduce my results using my patent and draft. They replicate it, then they can experiment it and go for some incremental improvement or drastic improvement. So I was granted patent when I submitted the detailed document to patent office. Now the patent application contains the complete description of method or process. Sorry. So complete method and process is there in my patent application, and my patent application has been made public, has been made available to public. So you can search for all the patents which have been published or granted till date through online search engines. And these patent documents or patent application is kind of complete enough, having all the detail so that you can replicate it. Now, since I have opened up my invention for public domain, in return, I'm getting some protection by IP rights. So it's kind of give and take. I'm giving to the society that whatever I have invented, I'm making it to public so that others can use it and improve it and do further inventions. In return, society is giving me back the 20 years of exclusive rights that this IPR only belongs to me. Any financial or commercial benefit, uh, I will get I will get the proper benefit. No other will infringe. So giving 20 years protection is allowing society to go through your invention and do something in addition to that. So in that sense, the overall patent system is encouraging for collaborative innovation and inventions. So criteria for getting a patent grant. Anyone can file patent, but it goes through examinations and controllers review. And mainly they look at this these three criteria: novelty, inventiveness, and utility. Novelty means it should not exist. The information and the knowledge should not exist already in the public domain. It may exist in the private domain, but not in the public domain. For example, uh, if we talk about the turmeric, so antiseptic properties of turmeric, some company in US was trying to get patent on this knowledge. Essentially, there were efforts also in getting patents for preparing that Bikaneri bhujia. So those companies were not given patent because there was not novelty. The uses of turmeric as an antiseptic, that knowledge is already existing with large number of Indian communities. So novelty was not there. Although the antiseptic properties of turmeric as a product was not patented, but since it was not having any novelty, so it was not granted. Then inventiveness. Inventiveness is directly related to non-obviousness. Now, it's a subjective criteria. Novelty is still, it's an objective criteria. You can search the literature, which includes historical books to the most recent advanced publications in terms of patent or research articles. But inventiveness is slightly subjective criteria. So we say, suppose if we are filing a patent in the domain of medical devices, the solution which you have come up should not be obvious to a person who is skilled in the art, in the sense who belongs to medical profession or say engineering profession. So if your solution is obvious for an engineer or a medical profession, then you may not get inventiveness criteria fulfilled for your solution. Of course, that solution will be non-obvious for some, say, maybe commerce or person with arts background, but not for engineers or doctors. So here, when it comes to subjective criteria, now you can imagine the examiners of your patent will also belong to your domain. So that is being generally done. So if you file a patent in a domain, so from domain A only the any examiner will be allocated for your patent. And they will judge the non-obviousness based on their knowledge or their limit. And most of the arguments for granting patent happens in this domain only for inventiveness. We have to justify why it's not obvious. Then third criteria is utility. So your idea should have some industrial utility. If it doesn't have the public benefit, there's no point of maintaining patent, granting patent, and unnecessarily increasing the number of patents in the database or something. Well, now let me give you example. Suppose I come up with a solution that I can build a stairs from Earth to Moon. So you can walk on those stairs and reach up to Moon. Walk or slide or whatever. Now, novelty is there, right? No one has come up with the idea of having stairs from Earth to Moon so far. And I am the first one to have come up with this solution. Inventiveness. I need to prove that for civil engineers or relevant people who are kind of in this profession of building large structures or small structures or elevators, for them, the solution is not straightforward. If, say, if I go to Mitsubishi for who builds elevators, if I go to Mitsubishi and ask for a solution to build an elevator from Earth to Moon, then if they also come up with directly the same solution, then it's obvious. If some inventive step is there, or many times in our Indian language we call it jugaad. So if that unobviousness is there, then we are good to go. Utility is also there. We can walk up to moon, bring moon rocks, moon dust to earth, do multiple experiments, so many things. So all these three criteria are getting fulfilled. What do you think? We will get a patent of it or not? The stairs from earth to moon. Mostly not, right? Because it's against law of nature. So if you are aware about the basic Newton's law or other physics law, this is not possible at all. The solution was novel, inventive, having utility, but not a good solution because it's not feasible. So any feasible solution can become eligible for getting a patent grant given it's novel, uh, it has inventive step, and it's also having some industrial or commercial utility. In general, duration of a patent right is 20 years. And you get this right from the date of filing. 20 years from the first date of filing. We call it priority date. So the date on which you have first disclosed your invention to public is priority date. And from that date to 20 years, you get your IPR, patent right. Only patent is valid for 20 years maximum. Now it might be possible that you applied for a patent, say today, 5th July 2022. You filed it as a provisional. Within 1 year, you can file the complete, and then it takes 1.5 years to get it published. Then it may take 2 years to 4 years to get it examined and grant. So essentially, you may get grant after 5 to 6 years or 7 years maybe. But your priority date will be considered as today's date. And your protection will be there for 20 years from now up to 4 July 2024. 2042. 20 years. So duration is 20 years. Then As already discussed, your patent rights are territorial in nature. So if you apply in India, you will have rights only in India. And if you want to sort right in other countries, you have to file international patent applications individually in other countries. What is the most important part of your patent application? Claims. All parts are important, but claims are the one which gives you the uh, legal rights. So whatever you mention in the claim, so if any patent case goes into court, they look at the claim. And if claim says something, that's your boundary of your invention. Outside claims, your rights are not protected. There are different types of claims like independent claims and dependent claims. So say claim one is generally independent, sorry, claim one is independent claim, and you can refer to claim one and further specify more details. If that is the case, claim 2 will refer to claim 1 and it will be dependent claim. Like I mentioned, whatever you defines in the claim, you will get legal protection. And you can design a claim such as some are broad and narrow. Broad in the sense, generally we would like to claim for broader things so that small variations becomes ineligible for getting patent by our competitors. So for example, say if I come up with an idea of say induction cooker. Now I say induction cooker is round like this, with some surface which is inductive, then some safety layer on top of it, something like that. So now if I go and file a patent on this particular design, my other competitors can say that no, our induction cooker is actually not round, it's a square kind of thing. And it also has some induction plate which consists of slightly different material. So here it's alloy, metal X of 90% and metal Y of 10%. I change the ratio here, X to say 91 and Y to 9%. Now all these small variations will not be allowed, but mentioning these specific values are actually your narrow claims. But if you say that it's an alloy buildup of X and Y in a particular ratio can vary from this value to that value. Essentially, we are defining more broader claims. So it's always good to have broader claims so that you can sort protection for your patent without worrying about small deviations which competitors can come and file. Then patent process. So first of all, you draft a patent application and you submit it to patent office. There will be some preliminary scrutiny, like whether it belongs to some invention related to defense or atomic energy. If yes, controller will put a stay order on your application and that application will go to central government for further consideration. If not, if your application is well within the boundary of Patent Act, then it will be hold for 18 months, and after 18 months it will be published. So by default, here the duration is 18 months. And remember that you can also file provisional. So provisional comes before this. And provisional to complete the specification, you again can get 12 months time. So if you start with the provisional, you wait for 12 months and then file complete. Then you wait for publication. So essentially, generally it takes 3 years. Publication of patent application doesn't mean the grant. Now after publication, again for uh, around 12 months or so, your application will be kept public, and there, so why we make it public? So that if any person is having any objection, any opposition on that patent application, can apply for pre-grant opposition. Generally for pre-grant opposition, time is given 6 months, preferably, but it can be more. After publication, within 6 months, you should apply for pre-grant opposition. Now, pre-grant opposition is something which anyone can apply. Say I file a patent, even a person not related to my domain or not related to uh, my field, also not in my vicinity, some remote unrelevant person can also file pre-grant opposition. And then if application fails through that period of publication and pre-grant opposition, application is sent to exam board of examiners for preparing the examination report. Then examination report comes, is prepared and shared with controller. Controller can either grant the patent or reject it. After granting also, people can apply the post-grant opposition. So generally, examination takes 1 to 3 months. And after this examination is over, you get some chance to respond to examiner's report. So here you have this FER, first examination report, and you prepare response. So if any objection is there raised by examiners, you get chance to put your uh, facts that why it should be considered for patent. And then grant is there, then post grant opposition. So for pre-grant opposition, people can use the argument that this patent knowledge has been uh, taken wrongfully from me by someone else and they have filed the patent. So fraudulent things we can have, or we can also argue that this patent is not representing anything which is inventive, it's obvious thing. So based on any ground, we can apply for pre-grant opposition. And pre-grant opposition can be applied by anyone, whereas post-grant opposition can be only applied by relevant person. a relevant stakeholder. Who is the relevant stakeholder? If because of this patent, competitors are facing some problem or they are unable to do something or progress something, then they becomes the relevant stakeholder who is directly getting affected by that grant of the patent. So in a patent document, we have front page which gives lots of information like bibliographic information, date of filing, date of application, date, priority date, country in which it has been filed, the patent application number, patent status, whether it's published, granted, or not granted, whether it's under examination, and some keywords. All those things you will find in the front page. An abstract gives you information, the overall information. Then written description. Uh, Here you need to write everything for which you want to get claims. And claims are like bullet points for which you are asking for patent protection. The description is like textual explanation. And then few drawings, supported drawings. And the way we use drawings are also standardized. So you cannot randomly put any kind of drawing. There's certain matter. Now, interesting question here to look is, suppose in my written description, I have talked about X, Y, and G, and in claims, I apply for A, X, and Y. So now there are three types of information we have. One is X and Y, which is present there in both the cases. Z is only in written description and A is only in the claim. So what will happen? For X and Y, you will get the patent if you prove that it's normal, inventive, and utility, given those conditions. For X and Y, it's straightforward. What about G and A? Any idea what will happen with G and A? So in written description, we have X, Y, G. In claims, we have A and X and Y. Anyone would like to make a guess? Okay. So G is part of your description. A will be examined. No, A will not get examined. And so what happened with G? Since your patent is going to be published, now your patent application is in public domain. So G will go into public. Now it becomes part of publicly available information. Now you can not apply patent for G. Although it's your application, you have made it public, but then you only sought protection for A, X, and Y, not for G. So G is not given you as IPR, and the description has reached to public domain, so it becomes public. A. For A, examiner will say that A is coming out of context. it has been never discussed in the description. So we don't know how A has come here in the claims. So they will discard the A and examine X and Y fully. Now later on, of course, you can amend your application and include A in the description. Then it is fine. But anything which is not there in written description but there in claims is not a valid use case. So claims, whatever you mention in the claims as a bullet point, should have some reference in the description. In the description, we generally mention the working of the invention. So if detailed working is there in the written description, and if any additional claim which is not necessary to explain the detailed working should not become eligible to get a patent. Another thing with patents are they are they are unique in nature. So they only represent a single invention. If you try to include multiple inventions in a single patent, that is not allowed. So it might be possible that you only require XYZ component in to work out that patent, and say G is already exist. You only sought invention for X and Y. But if you are also asking protection for A, now A is not an essential item as per this description. So by official laws, you are not allowed to include A as part of your claims. Of course, you can file another application which includes A, but not this application because A is not the part of essential solution which is described by the written description. So what is the advantage of patent search engines or information? You get up-to-date information. There's a uniform structure of all the patents, like the outline which we described. It will have front page, abstract, uh, written description, claims and drawings, and so on. Then it contains detailed description. So if your examiner is not convinced that given this much detail, if someone can replicate it, then examiner may ask you to redraft your application. So it's make sure that your detailed application contains everything which is essential to come up with the solution. Whereas in research publications, many times it's hard to reproduce the results. But in case of patents, they are quite straightforward. The unique source of information across the globe, we have large number of patents, patent database and search engines, and they are also well organized. We'll look at the demo also for how we can search for a patent. Then it becomes quick and easy to navigate through large number of patents. And patents are not restricted to particular technology. Most of our journals or conferences are related to some field, but patents are applicable to most of the field. Then, of course, citations are automatically generated when you submit an application for patent and you mention some relevant patents in it. So for each of searching, uh, we have IPC International Patent Classification. So it's a hierarchical classification system using which you can label your patents and classify them in a particular group. So, for example, uh, the first row in the table is the classification code for one of the class A21B1 slash 08. So A belongs to the higher lowest level of hierarchical level at the top, and it contains of 8 different sections. Then we divide this A class into B, and so it's a subclass. Like for example, class if section A belongs to human necessities, class A21 can belong to baking, which have edible dough. So two things are there in subclass. Then further divided that class into subclass. And this time we are further defining the field. So earlier it was human necessities, now we have reached to baking, and now we have baker's oven or machine equivalent for baking. Then we have groups. So generally main group have 00 as a subgroup, and then subsequently we have 01, 02, 03 subgroup. So this is kind of terminology we are going to use, and we'll learn how to use it, and then it will become much more beneficial and quick for us to do patent search. I will jump to the search demo. I'll share my another screen. So this is spacenet.com. It's a European patent search engine. And now we are going to quickly look at how to perform a search for relevant patents and how to search, dig it out from large number of patented documents so that it becomes easy for us to go through and find out whether we are really inventive or not, or we are infringing someone's patent or not. So let's take an example of, say, endoscopy. I'm searching for endoscopy. I hope my screen is visible. Yeah. So I click on the search button and I get 47,958 results for endoscopy. That's good, but we cannot go through all the results. So I'll go through few of these inventions title, patents title, and try to see if something I can get which is more relevant or not. So the disposable lightweight handle for endoscopy. System and method for virtually augmented endoscopy. So I'm interested in this one. Virtually augmented endoscopy. I clicked on this patent. I get some bibliographic details here. I can find other things like claims, description drawings, original content, citations are also here. Now, first you go through this paragraph, and if you find this patent is relevant, good to go, and if not, you click on say some other patent and find the first para abstract so that you get to know whether it's really relevant or not. So say it's relevant. So it's published as Europe. EP stands for European and World Organization, and US stands for US. So they have filed in multiple locations. And mainly we are interested in this classification, which we have just seen. So I generally follow IPC classification. So I click on this classification code. So it says this classification belongs to physics category, specifically instruments, and that too computing, calculating, or counting. And then it uses image data processing or generation or something. Then 15/100 gives you the 3D image rendering. Now, if it looks good to us that this is the category we are looking for, let's copy this category. Go for advanced search. Add a new field. And mention this IPC in this field. See 111 results only. So this example by chancely came good. So we have only now 111 results to go through it. And of course we can add more field. That field can belong to any text field like title, abstract. Title should say contain endoscopy. So we have only 14 results in which title is there with the word endoscopy. So this is the way you can do the faster patent search results. And also before filing, you should look into this relevant result so that you can be aware that whether you are infringing someone's patent or not. So that's about the demo. So you can do it same thing for different patent fields and others. Let me share again from the other device. So this is about how you can effectively use the patent search engine. And there are other patent search engines also, not only European based. There's an Indian patent search engine. The link is being shown here. And there's a US patent search engine. Google also has its own patent search engine. So you can use any of the patent search engine which is internationally acceptable for doing your travel art search. I'll quickly skim through other topics just to make aware that there are more things other than patents, given we have 4 minutes left. So there's a trade secret. Uh, Trade secret is like you keep something in your vault, your uh, in your secret vault, and you don't leak it out to your competitors. But if they can come up with the same solution, then you cannot sort protection. But if there's a theft of your trade secret, then you can go to court or in a legal case. So one of the famous example of longest trade secret is of Coca-Cola. So Coca-Cola has not applied for patent to sort protection for their formula, but they are keeping it trade secret, and they have some quite good strategy how to keep it trade secret, and they are also following the same method for their other varieties of cokes. So it's your responsibility to prevent a trade secret. You do not get any legal protection from government, and you need to do rigorous trade secret management in your organization. Why one should go for trade secret? Because patents have 20 years lifetime. A trade secret, like for example for Coca-Cola, it's more than 20 years easily now. And it also does not involve any registration cost, no disclosure required, no time limit. You can use immediately for your production. You don't need to wait for publication and examination and so on. So there we can have a long debate on patentable inventions as a trade secret, whether we should go or not. So it depends on all circumstances and various use cases. Then we have copyright. It's a legal protection given to author. So for software, you can have a copyright but not patent. So any original work which is related to writing or creativity goes as part of copyright. Originality have to be maintained for getting copyright. So it should be independently created, not copied from anywhere. And it doesn't matter whether it's a quality content or having some value or not. Whereas in case of patent, we bother about the utility aspect. But here we don't bother about the utility aspect for copyright. You can get copyright for any rubbish content also, because quality and values are not considered while granting. In many of the countries, they require uh, you to materialize your copyright in some form, say book or written article. Say if it's a song, it should be recorded on a CD. If it's a poem, it should be written on a paper. Then only you can apply for copyright. So that part of putting in some material form is known as fixation. Then according to one convention, if you apply in one country for copyright, or if you have copyright in one country, automatically you get in other countries also. And also it's a territorial again. And as you can see, you have copyright symbol using which you can notify the copyright. But even if you don't specify this symbol, then also it is assumed that you have copyright. So for example, these slides, I have copyright, whether I mention copyright symbol or not. Then there are various things which can be copyrighted, but Few things you cannot get copyright like idea, facts, your useful articles, the names, titles of the books cannot be copyrighted, slogans and short phrases. Official government work cannot be copyrighted. It consists of two types: economic right related to money, moral right related to giving proper credit to author. It's the last slide. I will spend maybe half a minute. For each copyright, we have related rights like performance. Like someone has written a song, but some other singer has sung that song, or some other dancer has performed the dance. So some other person has given the music to that song. So rights of performers belongs to the performers. The only lyrics rights will belong to the lyricist. Then there's a rights for producer who has produced the movie or audio album. So rights belongs to them. Then we also have broadcasting rights like for IPL and generally for cricket series or sports series or any reality show, we have broadcasting rights. So copyright, on top of the copyright, we have these three rights which helps disseminating the information to public. So copyright term is generally more lifetime plus 50 to 70 years. For India, it's 60 years. So if you have copyright, your legal heir can enjoy that copyright for next 60 years after your lifetime. And related rights are generally lesser, 20 to 50 years. So that's all. I'll conclude my talk here. And thank you everyone for your patience listening. And thank you, Dr. Shival and Kuldeep sir, for inviting me and presenting here on IPR. Thank you.
Thank you, Dr. Sumit, for a very comprehensive uh, talk on the IPR. I think people might have benefited. Uh, they must be thinking about all the aspects of the IPR, the process, the procedures, and what are the issues which are being commonly faced. We have shared a feedback link, so everybody has to give a feedback, and the recording will be available on the YouTube as well as on the NMCN network. So I request everybody to give the feedback also. Those who give the feedback will also receive the certificate, e-certificate. Yeah, question has been asked.
Yes, if there's any question or concern, please.
I think one somebody will raise the hand.
Good afternoon, sir.
Yes.
Sir,
Please.
can we patent a particular software testing of platforms? We are making different softwares or like even apps, and then if you want to test it, and we are designing new protocols for testing that apps. So can we patent it?
See, protocols are a different thing and your platform is different. So if it's a completely software, in US there are certain provisions where you can get patent for software in US. But in India, software is under still copyright, not as a patented. And regarding your platform, which you are saying, which allow you to create more softwares or more applications. But again, your platform is also, if it's purely software, then it's not patentable. But if you combine it with some hardware and show that this software will not work without this specific hardware. Essentially, you are showing it as appliance, then you can get a patent, but software is not patentable in India.
Okay, sir. Thank you.
Any other question or doubt or concern? Or you can also connect with me offline, my email.
Okay, if we don't have any other questions, so we thank on behalf of AIIMS Jodhpur and Institute Innovation Council, Ministry of Education, and the Institute Innovation Council of Ministry for encouraging the impact lecture on different aspect of the innovation. And this lecture was on the intellectual property right. We thank Dr. Sumit Kalra for a very comprehensive presentation of the IPR in a very explanatory method. We thank all the participants as well, and we request all the participants to also fill the Google feedback form. Based on this, you will receive the e-certificate also. Thank you.